Okay. That's kind of the nature of temporary injunctions, unfortunately. Tony, let's go on the record on DC 216103 Biote Medical versus Michael Antonelli. Counsel, make your appearances.
Thank you, Your Honor. Michael Pizzulli for Michael Antonelli and DNA Health.
Good morning, Your Honor. Elizabeth Brandon with the law firm of Reed Smith for Biote Medical. I'm joined with my colleague, Amanda Brown.
All right. Good afternoon.
Good afternoon.
Well, let's get started.
Your Honor, John Matthews here. I'm also assisting just with showing exhibits and things for my colleague, Elizabeth Brandon. It seems that someone had disabled the ability to share screens. Is there a way that can be enabled?
I just enabled it.
Oh, thank you very much. Appreciate it.
Okay, so let's go ahead and get started. We're going to start with, I guess, the temporary injunction, correct?
Yes, Your Honor.
Yeah. Yes, Your Honor. And I have, the witnesses from Biote that are attending. They're on the screen. Their video is currently off. I'm going to be making some arguments before I call a witness. And so once I call the witness, I will have them, appear on screen for Your Honor, if that's okay.
Okay.
Okay. So,
right.
Your Honor, thank you, Your Honor. Good afternoon. We're here on plaintiff's application for a temporary injunction, and it's going to be followed by a 15-minute hearing on plaintiff's motion to compel. I'll present evidence and argument on the temporary injunction, and my colleague, Amanda Brown, will address the motion to compel. And if we could, Mr. Matthews, if you could go ahead and share the screen and take us to slide 2. Your Honor, Biote is seeking to prevent a former executive employee from violating the non-disclosure, non-solicitation, and confidentiality provisions of his agreement with Biote. My client, Biote Medical, is a hormone optimization and medical training company. Can you go to slide 3, please? Defendant, Mr. Antonelli, was our former Chief Innovation Officer, and his single-member entity, DNA Health, LLC, is the company that Mr. Antonelli now operates to sell various nutraceutical supplements. These nutraceutical supplements are similar to products sold by Biote, and Mr. Antonelli is violating multiple provisions of his agreement with Biote. So today, you're evidence that Biote hired Mr. Antonelli in April of 2019 as a regional sales manager. The company trained him up and ultimately promoted him to a C-suite level executive. Next slide. On his first day at Biote, April 16, 2019, Mr. Antonelli signed various agreements with the company, including an NDA, a non-disclosure agreement that contained non-disclosure, non-solicitation, and confidentiality provisions. That same day, he requested an amendment. You could flip to the next slide. That same day, he requested an amendment to the NDA to carve out supplements from the 2-year non-solicitation period. And Your Honor, I know we sent you a courtesy binder of these exhibits for plaintiff's exhibits. And at this time, I'd like to move to admit plaintiff's exhibit H and plaintiff's exhibit I. These are the, April 2019 NDA and amendment to the NDA.
Any objection to plaintiffs H and I?
Your Honor, my understanding is H was the ethics policy, not the agreement. And if that is correct, I mean, it's not the same thing. And I is the amendment to the NDA. Of course, I have no objection to that.
Your Honor, may I respond?
How many? I did not get this binder. I apologize. I didn't know a binder was coming, and so I'm not actually at the courthouse. I'm doing this remotely. What exhibit numbers are you going to be introducing today? Because we don't have a whole lot of time.
Okay, yeah, it's plaintiff's exhibit H, which is
which exhibits are you going to be admitting today? Just H and I?
H and I. Oh, for today, I'm going to be admitting all the exhibits that are listed in that list. We're not going to go through, Your Honor, Many of these witnesses are being submitted in the interest of time, submitted by affidavits, and so there are documents attached to that they speak about in their affidavit. But I am moving to admit Exhibit H and Exhibit I. Exhibit H is the comprehensive document is an ethics policy and confidentiality agreement. That's the way it was actually submitted and signed with the parties. So the confidentiality portion of the agreement, or the NDA portion of that agreement, is starts on the 3rd page of Exhibit H. But I just wanted to clarify that. So our exhibits, for the record, are Exhibits H and I admitted.
H and I are admitted.
And I just wanted to give Your Honor some context because there are many different moving parts here. If we could move on to slide 6. In April of 2020, Antonelli was promoted to the Director of Business Development for Nutraceuticals. His new role meant that he was going to have more access to confidential information from the company. And so he was sent a new confidentiality agreement. So if you could go to the next slide. And this agreement, I'm going to also move to admit this, but this agreement included its own set of non-disclosure, non-solicitation, and confidentiality provisions. This 2020 agreement superseded the prior NDA and amendment. And this new confidentiality agreement is why we are here today, because critically, it did not carve out anything related to nutraceuticals. The amendment from the prior agreement did carve out a 2-year non-solicitation period for new supplements. This new agreement did not include that same carve out. And that's the crux of the basis of our claims today. Next slide. So, I don't think there's really much dispute that Mr. Antonelli signed the confidentiality agreement. At times in this litigation, there have been some statements, where defendants have suggested he didn't sign it. We just want to move to admit the affidavit of Jennifer Schimmel, who's the HR director at BioT. Ms. Schimmel's affidavit details how Mr. Antonelli received the confidentiality agreement electronically. He accessed it multiple times on different days. He signed it. It was automatically sent back to the company for execution. The process was much like a DocuSign process, except BioT uses the Adobe platform format. So let's move to the next slide. I'd like to move at this time to admit Exhibit A, which is the affidavit of Jennifer Schimmel, which also contains some attachments.
The objection, the Exhibit A. Hearing none, Exhibit A is admitted.
Now, in her affidavit, Ms. Schimmel explains the very process that I just described. If we go to slide 10, it attaches as exhibits 1, 2, and 4, the documentary proof of the execution. If we can move on to the next slide, slide 11. The evidence today, and Your Honor, this slide that's up on the screen, this is a document that was filed by defendants this past weekend. This is very critical to our arguments and claims in this case. The evidence is going to show that before Mr. Antonelli left BioT, he started plotting with other, at least one other BioT supplier, a vendor named TaylorMade. And unbeknown to BioT at the time, Mr. Antonelli was strategizing with TaylorMade to come up with a plan for Mr. Antonelli to separately sell nutraceutical products, similar nutraceutical products that BioT was selling. What Your Honor is seeing on this slide, slide 11, is the extract from the filing that Mr. Antonelli made this past Saturday that shows a privilege log, which we've been asking for several weeks, but they filed it this Saturday. They filed it publicly. And it details, starting in May, discussions between Antonelli on the one hand, which we believe are the initials MA and so forth, and Jeremy DAK is Mr. Antonelli's lawyers, we believe. We have many issues with this privilege log, but it at least highlights that Mr. Antonelli was engaged in discussions with TaylorMade. The individual named Jeremy Delk that you'll see throughout this highlighted portion is a principal and owner of one of the TaylorMade entities and so forth. You'll hear more about it today in testimony and evidence, but this just shows, Your Honor, that Mr. Antonelli was engaged with one of BioT's vendors before he left the company. Now, I like to just kind of identify for the court the additional affidavit testimony that the court will hear from, will receive today. Slide 12. You already heard, we've already admitted, the court's already admitted Ms. Schimmel's affidavit. But the additional components of Ms. Schimmel's affidavit is that she will explain how she reminded Mr. Antonelli about his obligations once he had left the company. Let's go to slide 13 real quick. We'll come back to slide 12. She reminded him that his employment and affiliation with BioT ended on August 13, 2021. And what you're seeing here is an extract from an email on September 20th, 2021, where Ms. Schimmel is advising Mr. Antonelli that he needs to return the company issued, laptop and equipment. He'd been gone from the company for over a month at this point. Since the parties weren't able to reach any kind of independent contractor agreement with him, he had no reason to continue to hold on to the company device. So she instructed him to return BioT issued computer and iPad and so forth. And then next slide, go back to slide 12, please. You'll also hear from an affidavit from one of BioT's IT managers. His name is Ashton Solomante. He's the one that's identified on the slide there under Plaintiff's Exhibit C. His affidavit explains really the chain of command of receiving this device from Mr. Antonelli when he finally returned it. He explains that he received it from Mr. Antonelli on October 27, 2021. This is like now 2 months after he'd left the company.
I'm going to object. This is pure argument. She ignores the fact that we had been negotiating for some time to work out an arrangement where Mr. Antonelli could get his private information off of that computer, and that she completely refused to cooperate in any way. So I object to the sidebar remarks and the argument that is inconsistent with the facts, Your Honor.
I'm a little unclear kind of what we're doing here. So it seems like you're kind of doing a combination of an opening statement and kind of presentation of witnesses. Are you?
Yeah. I'd like to, yeah, Your Honor, if I can.
And understand we only have 30 minutes for, you talk about we're going to hear this testimony and that testimony, we only have 30 minutes. So you've used about 20 minutes so far. So maybe just kind of give me an overview. Are all of the witnesses testifying via affidavit?
No, Your Honor. The witnesses that are on this slide, Jennifer Schimmel, John Bickle, Ashton, and Jason Sue, are all testifying by affidavit. We've moved to admit all of their affidavits at this point. We have one live witness who is going to testify. And I can just move on. We can stay on this slide. Mr. Sue is the one that actually conducted a forensic analysis on the on Mr. Antonelli's laptop when the company finally received it back. He is a tech that's associated with Reed Smith, and the forensic analysis shows, if we could jump to slide 14 and 15 and 16, it shows.
For the record, we object, and we have objections to these documents. So if she intends to read off of documents not admitted into evidence, I would like to make my objections. I don't want to interrupt her. I do have a little objection piece of paper which I can use. I'm trying to be polite, but I do have the right to object before she goes into the documents.
Your Honor, at this point, the testimony from Mr. Sue is testifying to what he uncovered, and the documents attached are the process that he entailed he utilized to conduct the forensic analysis. And so we're just moving to submit the affidavit testimony for these individuals. If there's an objection to the actual, an evidentiary objection, I haven't heard the grounds, because Mr. Sue's affidavit details what he actually did and the data he pulled. I don't need to read from the materials, Your Honor, but the reason this background is important is because the live witness is going to kind of talk about what the company found out. And that relates to these materials. And so that's why I just would like to go ahead and move for the admission of these 4 affidavits and all their exhibits.
Object. In particular, the affidavit of John Beckel is hearsay and hearsay upon hearsay, and therefore it is completely inadmissible, Your Honor. The affidavits of, I think and I'm trying to go through the affidavits as quickly as I can, of the other 2 people, Mr. Solamante.
Why don't we do this? I think this is going to be a more effective use of our time.
Yes, Your Honor.
Because we only, as I've said a couple times, we only have 30 minutes. What I think would probably be the best way to do this is, have you 2 conferred about these exhibits at all?
No, Your Honor, I got them 2 hours before the hearing.
Yeah, and I don't have them. And so I may ask my coordinator to deliver them to me, because I'm working remotely right now. What I would suggest we do is maybe deal with whatever issues we have with the motion to compel, and then reconvene this hearing maybe tomorrow or Wednesday potentially, to try to finish it. And then in the interim, you guys could talk about these exhibits and figure out what you're going to object to, what you're not going to object to. So how does that work time-wise? Could you guys do this tomorrow or Wednesday?
I have a 10:30 tomorrow, and I have a doctor's appointment in the afternoon on the 26th, Your Honor. And if the court feels it important for me to cancel my doctor's appointment, I will. I'm available.
What time is your doctor's appointment?
3 p.m.
On what day?
Wednesday, sir.
And what about Tuesday?
I have a 10 o'clock on Tuesday.
10 o'clock doctor's appointment?
No, it's a conference with the law firm on a different matter.
Okay.
Your Honor, my schedule is a little bit more complicated, and I know we have a witness here who's available to speak now. We'll, of course, work and accommodate whatever the court instructs us to do. I did want to inform the court that I am actually in active trial now in Seattle, Washington, and I'll be actually in trial later this week. We're somewhat hybrid, but we're there in person, and so it's a bit of a complicated process. Now, if the court wants to reconvene this, I mean, my colleague Amanda Brown would be available if that's what the court instructs. We do have an executive, the CEO, here to testify, and will be available to go ahead and proceed with the live testimony. And then, I guess the parties can confer on the remaining exhibits that can be just submitted to the court by submission, and maybe just have a hearing on the admissibility of certain exhibits.
We have, I can push the next hearing a little bit, but we have 10, 15 minutes left at most. How long is it going to take for the CEO to testify?
I think we would need about 20 minutes, Your Honor.
Mr. Bazzulli, are you going to have any cross?
I don't know who the CEO is that they're calling, Your Honor. So I would anticipate having a cross, but I don't know who it is.
We submitted a witness list on Friday. We filed that identified all of our witnesses, including the CEO, Ms. Terry Weber. So that was disclosed prior to today, Your Honor.
Can everyone reconvene this tomorrow afternoon? What if we did?
Yes, Your Honor. I can do tomorrow afternoon.
Your Honor, subject with me conferring with our witness, of course.
Yeah, go ahead and ask her.
Okay. If I could just step away for a moment.
Sure.
Now, don't unmute. We want to hear.
Thank you, Your Honor, for that indulgence. And yes, the witness will be available tomorrow, and we will all make ourselves available at Your Honor's convenience.
Okay. Let's shoot for 1:30 tomorrow. In the interim, let's go ahead and you guys confer. You said you have how many total exhibits do you have?
We have a total of, all right, so it's, we put them by letters. So there's a total of A through W.
Okay.
That is, 23.
You've got A 1 through 8. So you've got a subset inside of 2 of your exhibits.
So yeah, I believe Exhibit A, those attachments were.
There are 8 of them.
There's true. There are some subsets, Your Honor. We'll confer.
Yeah, why
I
don't you guys confer? One other question I have. So let's kind of put this in context right now. So there's a TRO in place, is that correct?
No, Your Honor, there was no TRO requested.
Okay.
Your Honor, yeah.
Go ahead.
Yeah, Your Honor, we were just saying, I was just going to say that's correct. There is no TRO. We had moved for expedited discovery so that we could engage in some amount of discovery in advance of today's hearing. And defendants filed a motion to dismiss under the TCPA. And so therefore there was limited discovery related to our, opposing their motion to dismiss. So in the interim, we still had the TI hearing set, and we wanted to, and hence the reason why there's so much fulsome evidence that we need to submit and to make this record complete.
So have you guys taken depositions of all these folks who had the affidavits
No, Your
submitted?
Honor. No, Your Honor.
No, Your Honor. And the reason that it's that way, Your Honor, frankly, is that plaintiffs proposed expedited discovery, mutual expedited discovery on both sides, and defendants refused. And in response, they filed the motion to dismiss under the TCPA, and then took the position that we don't get any discovery. So then we had to divert and then seek discovery to address in preparation for our opposition to the motion to dismiss. So in connection with that, Your Honor had a number of hearings last month and ordered very tailored, narrow discovery in connection with the motion to dismiss and our opposition to that. We were able to take two depositions of one of Mr. Antonelli personally and one of Mr. Antonelli in his corporate rep position. In the meantime, there was no discovery on defendant's part because as they understood the effect of the TCPA motion to dismiss, discovery was stayed. And so that's the reason we are in this posture that we're currently in.
Okay, that makes sense.
Yeah.
It makes sense. All right, well, that's it's kind of a problem of your own. Thank you, Mr. Bazzulli. You filed the TCPA motion, which is you're right, but it does limit discovery. So this is the way we have to do it. Unfortunately, I normally would have let you have the opportunity to take the depositions of all these folks. But
Your Honor, I agree with you. You wisely pointed out when I said, well, can I have some discovery? You invited me to drop the TCPA.
And I don't know if you've been watching what the Court of Appeals are doing with these, but the TCPA is not what it was before the amendment. People are not, the courts of appeals are, especially Dallas. I think you're, anyway.
Well, let me just say, Judge, I'm going to rethink that. I completely agree with you. This is my 4th TCPA. 3 of them, I was the recipient of the TCPA motion. And I have appealed one that fully argued it in the Court of Appeals. 49% of all appeals to the Dallas Court of Appeals now are TCPA.
Really? Wow.
And that the legislator who wrote the amendments in 2019 in the legislative history said it is the most litigated statute in Texas history.
Yeah.
So I'm rethinking it, and let me talk to opposing counsel about maybe we'll just withdraw that motion so we can get going on discovery. And your idea initially was probably the best idea. And you're right. The courts have completely done a 180 on the TCPA.
Okay, well, just why don't we do this? Let's, do you want me to put you guys into a breakout room, or kind of what do you want me to?
I'll do anything that.
Well, we would like to go ahead and at least proceed on the motion to compel argument to the extent that the court has time, and I'm happy to go into a breakout room.
Let me ask, Mr. Rickman, are you there?
Yes, I am, Your Honor.
Okay, is your opposing counsel here?
I have not seen Drew Siegel pop into the Zoom conference yet.
Okay, well, okay, we have time. The other side's not here, so all right, let's go ahead and hear the motion to compel.
Yeah, Your Honor, may I just ask one more thing in connection with the temporary injunction hearing? While we still would like to proceed with that as expeditiously as possible, this hearing has been set for 2 months now. And so we would be very concerned about the prejudice that we faced and not being able to engage in discovery 2 months if Mr. Pizzulli is willing to withdraw the motion. But that's, I just wanted to let the Honor be aware that we still do want to press forward with that TI hearing as soon as possible.
Okay, that's fine.
I would meet.
I would just say this: if he withdraws the TCPA motion, it would allow me. I would consider some minor additional discovery at that point, but possibly taking. Usually, what I do in this situation is allow anybody you want to submit by affidavit to be deposed. But anyway, just a thought. A motion to compel. Go ahead.
All right, Your Honor. So this is BioT's motion to compel. And as Ms. Brandon alluded to earlier, we had 3 hearings before you in December to figure out the scope of discovery after defendants filed their TCPA motion. And ultimately, this court granted us a limited set of RFPs and then a deposition of each defendant for 2 hours. So after we had conferred and reached an agreed order on the discovery that was authorized by the court, defendants served an incomplete production. We sent a deficiency letter. We then deposed the defendants and found out even more documents that had not been produced that were responsive to the request. We sent another deficiency letter on the 14th, and then just this morning we received some additional documents. And then, as Ms. Brandon alluded to, on Friday we received the privilege log that we've been asking for. There's still several documents that are outstanding that we believe are responsive to the request, and we also have issues with the privilege log, which, as you saw, is deficient under the rule to allow us to sufficiently assess whether the information being withheld is privileged. And it also appears that the dates on the privilege log, that there's some subsequent and previous communications that are not included on the log. So the items that we've been asking for that we have not received to date include the asset purchase agreement that Mr. Antonelli entered into on July 14th, 2021. And as we learned during his deposition, that asset purchase agreement relates to not only his purchase of BPC 157, which is a nutraceutical that's part of this, the subject of this TI, but it also includes his purchase of some non-BPC assets that reference BioT's financial information. And what he did is he produced a copy of the APA, or the asset purchase agreement, that's literally one paragraph excerpted and then some redacted introductory paragraph. So it's not even the complete agreement redacted, it's one paragraph that they slapped on with the introductory provision. And we're asking for a complete copy of that agreement because, as Mr. Antonelli testified in his declaration that was attached to their motion to dismiss from under the TCPA, he purchased the BPC 157 assets prior to his leaving BioT and forming as part of his formation of DNA Health. And at his deposition, he testified about several provisions in that agreement that we don't have. He testified that he's a seller or a purchaser under that agreement, even though he's listed as a seller. And so what we've done is we've asked for a copy of that agreement. Mr. Pizzuli's moved for in-camera review. We have an agreed protective order in place. So our position is that if it's as sensitive as he claims, we can go through the protective order route and it can be designated as AEO, but we need to see the whole agreement. One of the requests that was authorized by this court is documents that relate to the formation of DNA Health. And as Mr. Antonelli has testified, this asset purchase agreement was the impetus for the formation of DNA Health. It gave him the assets to form DNA Health. And so that's the first document at issue that we want to see, Your Honor.
May I respond, Your Honor?
Okay.
Thank you. First, I respectfully disagree with the majority of what opposing counsel said. And I really think that the Texas rules of civil procedure don't say because you have a protective order, a document you're not entitled to, you can just see and decide for yourself. What we did was we extracted, because the order that the court entered said they are only entitled to documents that relate to BioT. And there was one provision in this multi-provision document that related to BioT, and that is the sale of BPC 157 to BioT. We extracted that and produced it to him. Ma'am, are you shaking your head because you don't agree with me?
I do disagree, Mr. Pizzuli, but I'll let you finish.
I appreciate it. Thank you. The fact is that one document, the one paragraph, paragraph 14, specifically related to BioT, which is what your order said we were supposed to do, and we gave it to them. The rest of it is highly confidential, third parties involved in a transaction for the acquisition of a company that has nothing to do with BioT, has nothing to do with any rights that they have, and has nothing to do with the orders that this court has entered that they are permitted to have. So what we did was, which I thought was the appropriate method, Your Honor, which was one, provide to them the provision under protective order that complied with the court order. Two, request that the court do an in-camera inspection of the document prior to production, and then let the court determine whether or not it is subject to the orders of this court. That is, as far as I can tell, and as far as the statute that I cited says, is the correct way of doing it. And that's all we're requesting, is that the court see the document first. We didn't conceal it from them. We disclosed the document. We produced the part that was relevant to the court order, and we've asked the court to review the balance of the document.
And I would say, Your Honor, that the court's order was not as limited as Mr. Pizzuli indicates. One of the specific RFPs authorized was all documents related to Michael Antonelli's preparations to form DNA Health. The court also authorized an RFP for communications between defendants and some other third parties, including Tailor Made Health, which is one of the parties to the agreement. And as we've learned during Mr. Antonelli's deposition, I mean, there's several provisions in this agreement, including the ones referenced in his declaration, that are relevant to his formation of DNA Health.
Let me ask this, Mr. Pizzuli. So you've redacted most of this agreement, I guess.
Jonathan, could you pull it up, please? Sorry, Your Honor. I just want you to see what he's produced. It's slide 25, Jonathan.
I'm sorry. I'm happy to answer the court's question.
Yeah. So you produced certain documents, but they're redacted. Have you produced to the court the unredacted versions?
No, Your Honor. I filed a motion for in-camera inspection. As I read the rule, once the motion for in-camera inspection, if the court determines that is an appropriate remedy, I am to put it in a sealed envelope and deliver it to the court, but it's not to be delivered to the court until the court makes that rule.
Okay. Go ahead and share screen it.
Amanda, can you confirm what you need? Slide 25, I believe, is a timeline of sorts.
I believe I have it up. Can the court see it?
There we go. Yep.
This is what they produced, Your Honor. It's a single page where they've literally copied and pasted one of the paragraphs. It's not a redacted copy of the complete agreement. It's one that they've created on their own.
Okay.
If I may respond, I did not redact paragraph 14. That is the one paragraph in the entire document that really related to BioT. We produced it to them, and we requested that the court, because of the highly confidential nature of an asset purchase agreement, and in my view, BioT wants it to determine what we're doing in the industry, not for any purpose in this lawsuit. So we're asking the court to review it I can have it delivered down to the court.
So let me ask you this, or both of you this, how many documents are we talking about that there's an in-camera request for?
One,
Oh, this is it?
This is the only in camera, Your Honor, but there's several other documents that are the subject of the motion to compel.
Well, let me ask Mr. Rickman, is your opposing counsel here yet?
Yes, Your Honor. I think Ramon Rodriguez is going to handle this for the defendants.
Okay.
Correct, Your Honor. I'm here.
All right. So, Mr. Mazzulli, I guess so we get something done here. Let's go ahead and have that delivered to the court.
yes, Your Honor.
I need it to be, I'm trying to think of the best way to do this. Let me go off